Oh, I see. Yeah, I see what you're doing. Yeah, no, that's fine. Perfectly fine.
Thank you so much, Your Honor.
Okay, no, it's all good. So. All right. Is there anything, is there any reason why anybody believes that they could not serve as a fair and impartial juror in this case if selected to serve? Please raise your hand. If you are in this room, you should anticipate that you will be on this jury. So if there is any reason that any of you have that causes you to think why you could not serve, on this jury, please raise your hand. No response. All right, counsel approach, please. All right, ladies and gentlemen, what we're going to do at this point, oh, sorry, Beck. Ladies and gentlemen, what we're going to do at this point in time is we are going to select the jury in this case. The jury is actually selected by a process of deselection, and we've spoken about that before. What that means is that you will see the attorneys handing a sheet back and forth between themselves, and when we get done, I will read the numbers of the jurors who will, or the numbers of the people who will serve as jurors in this case. Okay, let's check. 2, 3, 4, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 22, 23, 26, 27, 28, 29, 30, 31, 32, 33, 5, 36, 37, 38, 32, 6, 47. And this does take a while. I think what we'll do is, well, actually, for this part, we do need to have everybody in the jury room, or in the courtroom. So it will take a little bit of time. You can feel free to stand, stretch, talk quietly amongst yourselves if you want to do that. That's right. I heard a voice somewhere. Oh. Hold on. Juror 20, yes, ma'am. Have they been given any more information about you? Was that the question? Not for me. No, anybody is, it's not uncommon that one side or the other, or both, will sometimes see what information they can find out about a potential juror, a potential judge even, and potential witnesses. But there's no other information that was given to anybody by us, by the courts. Maybe that's the best way to put it. Does that answer your question? Yes. Right. Right. Yeah, those questionnaires that you filled out. Right. No, remember the comments that I made was that the court staff, the attorneys, and their staff will know who you are, but nobody else does. because constitutionally they're entitled to know that information. No one else is. Does that answer your question? Okay. I'll double check, but they should be. Counsel, while I'm doing this, I want you two to compare with each other. Compare with each other, and we'll do the same once I get it marked out. Council approach, please. Okay. Okay. Stack these 9 and 9 instead of. Makes a little more sense that way. All right, what I'm going to do now is, much like we did on the other days, I'm going to tell you to stay in the courtroom and who is released. But everybody wait in your seats. I'm done because I have the attorneys confirm that this is, in fact, the jury. So juror number 1, you'll be staying. Juror number 2, juror number 3, 7, juror 13, juror 14, Right? So those people whose numbers I have called, stay in your seats. Everyone else is released with the thanks report. So let's do this. Juror number 7, if you move down here next to juror number 3, and juror number, actually, let's do it this way. 14, if you'll take that seat right there. 13, if you'll take the seat in between. Juror 13. Seat next to juror. Seat. Follow her. Juror 65. Seat next. Just follow him. Seventy. Seats here. All right. Here's what we're going to do. We're going to take about a 15-minute recess. What's going to happen is that Mr. Combs and Mr. Sproul are going to show you where it is that you meet, because now things change. What will happen is you'll come into the courthouse. Mr. Combs will meet you at a place. He'll talk to you about that, about how to get into the courthouse. He'll bring you in, and you'll come down the back hallway instead of the front hallway. And there's 2 rooms back here that we have for you, actually. So they'll go through that process. He'll explain how to get back there, what it is that you need to do to contact him. We also will have some juror buttons for you. We will have sort of a tablet that has some notebook paper and some pens and things like that. And if I can, before we go much further, if I can have everyone stand and raise their right hand, please. Do you solemnly swear or affirm under penalty of law that you and each of you will well and truly try the matter at issue between the people of the state of Colorado and Letecia Stauch, the defendant, and render a true verdict according to the evidence?
Yes.
Go ahead and have a seat. Now that you've been selected as jurors, there are some rules that you must follow. These are the same rules that jurors have always had to follow in every case. During the trial, this courtroom is a place partially isolated from the outside world. Your decision must be made inside this place, and you must follow its rules. You must decide this case based only on the evidence and the law presented in the courtroom. You must avoid any other information about the case from any other source. These rules are designed to make sure that this is a fair trial. There are two basic rules. First of all, you must not communicate with others or among yourselves about the trial as it is going on. You cannot discuss the case while it is pending. You can talk about all kinds of things back there, just not the case. And I know it's a natural reaction that, what did you think about that witness's testimony as soon as you get back there? You simply cannot do that. In addition, you must not do any independent investigation or research about this case. I want to go over these rules in some detail because they are very important. In addition, if I learn that any of these rules have been violated, it may be that we have to start trial all over again on a new date in front of a new panel, and we have to go through the whole process again. So these rules are very, very important. Please follow them. You must not discuss this case among yourselves in any way during the course of the trial. You may not discuss the case among yourselves until after you have heard all of the evidence and you begin to deliberate on a verdict. That's when all the evidence is done. I've given you the instructions and you've heard the closing arguments. In fairness, you must keep an open mind throughout the trial, and you should reach your decision only during your deliberations at the end of the trial. Do not permit anyone else to discuss this case with you or near you. If anyone, including one of your fellow jurors, attempts to do so, please report that fact to Mr. Sproul or Mr. Combs immediately. You are permitted, however, to explain to family, friends, and employers that you are on a jury, and you can inform them of how long the trial will last. You cannot say anything else about any aspect of your experience until you are released from jury service. Do not communicate with anyone else in any way, including in person, by telephone, cell phone, computer, the internet, or any internet service. This means you must not email, text, instant message, tweet, blog, or post information about this case or about your experience as a juror in this case on any website, listserv, chat room, blog, or website. That's really important. We had a case not too long ago where they were about, actually, I think they were in deliberations, and one of the jurors was starting to blog about their experience. And a mistrial had to be declared, and they had to reset the trial and start all over. Once this case is done, you can talk to anybody you want. You can tell them as much or as little as you like about the process, but while it's going, you can't. You must not read, review, or accept any communications in any form from anyone regarding this case or cases like this. This applies whether you are here, at home, or anyone else. Do not read about this case in the newspapers or on the internet, or listen to any radio or television broadcasts about the trial. The law even prohibits you from consulting a dictionary to clarify terms that may be used in this case. Why do we have such a long instruction on this? Because in my experience, I think jurors are trying to be conscientious. I think jurors sometimes go home and they say, gee, I didn't really understand that. They try and look something up so that they can have a better understanding about what's going on in the courtroom. You can't do that. Here's why. First of all, before any evidence can be presented in the courtroom, it must be allowed pursuant to the rules of evidence. This book. It's in this book. The Rules of Evidence governs evidence that's admissible in any trial, whether it's civil, criminal, otherwise. And those rules are in place to make sure that the evidence that you're looking at is reliable and it's admissible. And you may be looking at something on the internet, on the news, or whatever, and I can fairly guarantee you that that does not meet the rules of evidence for admissible evidence in a courtroom. In addition, before you receive evidence in this case, as I said, remember, nothing that the attorneys say ever is evidence. Evidence comes from somebody who comes up here, swears to tell the truth. You won't see the attorneys do that. You won't see anybody on the news do that. You won't see anybody on the internet do that. So they come in, first of all, they swear to tell the truth. Secondly, they're subject to questioning and cross-examination by both sides. And that's, it's referred to sometimes as the crucible of cross-examination, to make sure that the information that you get is truthful or is accurate. And if you're looking up things or you're talking with somebody else, neither one of those are going to apply. So make sure that you don't do that. In addition, if you were to do that, I've told you that you can't discuss this case among yourselves. You can't discuss it with anyone else. If you had done that, no one would know that you had done it. And it's possible that you may be making a decision in this case based on information that neither side knows about. And that's just not fair. We don't decide things on secret information in a courtroom of law. Breaking any of these rules would violate your oath and could require a new trial before a new jury. Your misconduct would have wasted all the time that you, your fellow jurors, the court, the attorneys, and everybody have spent in putting this jury panel together and putting this trial together. So please, please, please do not do those things. Again, after trial is over and you have been discharged as jurors, you're free to discuss anything that you want to with anybody that you want to. You just can't do it while we are in trial. So what we're going to do is take about a 15-minute recess. When we come back, I'll have some further instructions for you and tell you what you can expect this afternoon. With that, all rise for the jury, please. Thank you. You may be seated. Record should reflect the jury has left the courtroom. So the plan is when we come back, I'll go through the preliminaries of what the jury can expect this afternoon as far as opening statements, those sorts of things. And then opening statements at 1:30, an hour per side. I'm not going to require evidence. If you have some that you want to put on, if you're not ready to put on evidence until tomorrow, that's fine. I told you that you didn't have to do it today, but we're a little bit farther ahead than what I thought we would be. So
the first witness that we intend to call, we've already told them.
it's a long day for them. I think it may be, a lot for them to process and getting back and forth and all of that stuff. So that's fine. If we end up at, let's see, 3:30 or so, I'll let them go home. And then we will start up with evidence tomorrow. During the lunch break, you need to do whatever it is that you need to do to make sure whatever it is that you want to do, video, audio, all of that stuff is all ready to go. Are you planning on using photos, anything like that in your opening statement? Have you told them what it is? Okay. Okay. All right. Just want to make sure. You're playing it from your laptop?
Yes.
Okay. Yeah. Yeah. That should be fine. I should be able to regulate it from up here. The issue will be, I don't think it's connected to the microphones. Hold on just a minute. We should be okay. Yeah, that'll be fine. Okay. And Mr. Tellini, you wanted to renew your motions? Or did you have anything else? Sure. Okay. All right. Then we'll take our break now. All right. You want her? You want her at the table or in the?
No, you can
behind
find
you?
in the gallery, but
Okay.
maybe coming in out.
That's fine.
Anything, maybe.
You will need to let security know who that is because everybody else, I've said everybody aside from staff and people that are associated with the case, once they leave, they don't get back in until we take a break. So just let them know who it is. All right, court will be in recess then. Say 11:20.
It's really challenging.
We're gonna work on that side. Okay, we're good.
So strapped you got. And then you push. Yeah. And that's all spread out. You're a genius. Tomorrow.
Tomorrow, yeah.
Okay.
No. Thank you, guys.
The ones.
Okay, I have more. No, I have more. Did you spill coffee on that one?
Smarted myself. So I can't. It's just.
So it's easy enough to do. No, it's easy. It's easy enough to do. You don't sound a whole lot better.
Me?
Yeah.
Yeah, I'm.
Still bothering you, huh?
I feel okay though.
Yeah. No, I mean, it's just, you can hear it in your nose. So.
It's his fault that now I'm stuffed up today.
Right down the line.
There you go.
That's why I stay away over here. There's a lot of sick kids out there right now. And there is a vicious stomach bug. Yeah. I think you're more, when you still have kids in school, you're more
And that's true.
to what's going on.
All of our questionnaires.
Okay. Yeah. Just put them on Mr. Combs' desk.
Including all proceeding charts.
Okay. Thank you.
Video.
Pardon? You mean the screens?
No, the,
Oh, no, I might start it when they come back. Well, yeah, because there's not a way to, we're not set up for it right now. So I'll start the video after lunch. Yeah.
I just want to know when we're live streaming or not, so
That's fair.
I should know when to, yeah, I'm trying to picking my nose.
Anytime.
What?
That kid all the time.
You know, sometimes.
It's all I can look over here.
Just trying to work a check.
You want me to work out the podium here?
More than happy to. Jason, where's my? Said I want to come.
Okay. Sure.
First off, Your Honor, I am reaffirming my motion for a change.
Just a
I
second.
would add this to the last.
5 minutes.
Yeah.
5 minutes.
Okay.
Yeah. Okay. Go ahead.
Because this one was the last motion that I filed in the confirmation box, there's already expressed a preconceived that my opinion, that is not a fair and impartial jury. I also cite the court to people, Botham, Colorado Supreme Court, 629, 589, Colorado Supreme Court. And a lot of similar issues that we have here where there is overwhelming media presence. Much like Botham, the vast majority of jurors here publicity had a that indicated that it had influenced. They cite in that a case from the United States, for Florida, that's that 95 SC, 7. Quote is, in a community where most veneer men will admit to qualifying prejudice, liability of other protestations may be drawn into question. Or is it more probable that they are part of a community deeply hostile to the accused? Or likely they may unwittingly have been influenced. And so on that, I would rest on my motion.
Okay. Prosecution.
What we learned during jury selection is that while there was certainly a lot of media coverage for this case, jurors that were seated just early, extensive examination by both parties and to that if they had seen are able to information on trust and respect what we do in the justice system and know heard of media coverage good in this case based on what happened. That we ended up seeing a sworn in all understood those. Still two other motions out there.
Okay. Hold on just a moment. All right. First of all, I've made a ruling regarding this before. I would reassert that ruling. But in addition, we've gone through, well, first of all, everybody wanted to have a questionnaire about what people knew about this case, and I thought that that was appropriate. It was something that we were going to have to deal with, whether we dealt with it in a questionnaire or whether we didn't. But the questionnaire was provided prior to the time that any of the jurors received instructions on the law and what it was that was required, the presumption of innocence, the beyond a reasonable doubt, the right to remain silent, those sorts of things, which is something that all the jurors were advised about during the voir dire sessions. In addition, the jury has been seated at this point in time, And one of the instructions that I gave them was they can't do their own research about any aspect of this case, and they can't rely on any media and those sorts of things. And I told them why. And that's because of the applicability of the rules of evidence, and that whatever they heard or whatever they listened to was not subject to the same things that evidence in a courtroom is, such as the witnesses are sworn to tell the truth or they take an oath to do so. They're also subject to cross-examination and examination by the attorneys, and any of the evidence that is going to be admissible must be admissible pursuant to the rules of evidence. So I tell them why they can't rely on it. I think that it goes against common sense to say that because someone has an opinion about something means that they have to be disqualified per se. In People versus Drake, 748 Pacific 2nd, 1237, Colorado, 1988, the court said that the test to be applied in determining whether a prospective juror should be dismissed for cause is whether the person would be able to set aside any preconceived notion and render an impartial verdict based on the evidence adduced at trial and instructions given by the court. And all of the jurors in this case have said that they can do that. They all seem to understand the court's instructions. In fact, when I was telling this jury panel why it is that they couldn't do research about anything and why they shouldn't listen to the media and those sorts of things, I got a number of nods of the head as to, indicating to me that seemed to make sense to them. So that the motion for change of venue is denied. In addition, it would be difficult for, essentially, I think it was Judge Schwartz that had the story about he moved a case to, I believe it was Durango, based on pretrial publicity. And then the Sunday before they were supposed to start jury selection, the local newspaper ran a story about everything that was in the case. Again, I think given the coverage that this has had, we need to keep in mind that we need to have some sort of venue to try it. I would note that this case is not really different than the Dylan Redwine case that was tried in, was it La Plata County? It was down in Pagosa Springs. The Holmes case that was tried in Aurora, and those sorts of cases. So the motion is denied. Are there any other motions we need to address?
Because I think, and I don't. For me,
Oh,
which
all right. Defense?
Stauch's opinion.
All right. And just so that the record is clear, Ms. Stauch, you wish to waive a jury and have this case tried to me? Okay. Let the record reflect that the defendant responded yes. Again, I think that the case law is clear that in some cases where a jury cannot be, where a fair and impartial jury cannot be seated, that the court has a constitutional obligation to make sure that the defendant has a fair and impartial jury. And if one cannot be seated, then the case should be tried to the court. Having said that, the law is also clear that absent that circumstance, the prosecution has a right to have this case tried to a jury. And I believe that I have put mechanisms in place to make sure that we have a fair and impartial jury. And as a result of that, I do not believe that it is necessary that I and I alone decide these issues. As a result of that, the motion to waive a jury is denied. Is there another motion? Okay, we good? Let's
Yes.
bring him in. And just so that you guys know, now use the front hallway. Use the front hallway when you're coming in. So it's just flipped from what we did before. and each side will have a reserved pew, I guess, behind them. Yeah, that bench behind you, that first bench is reserved for the defense, that first bench reserved for the prosecution.
That's the only,
That's the DA's problem. And you can let them know that if there are issues that I need to address, I will address them. What? You would have to ask admin, but not as far as I know. Because we're doing it as a live webinar, not as far as I know. I frankly don't think there's any space. All rise for the jury, please. It's okay. All right, thank you. You may all be seated. Again, good morning, ladies and gentlemen. I wanted to apologize because I forgot to tell you one of the most important things that you need to remember before you left the courtroom. And that was look to your left and make sure that the person that is to your left comes through that door before you do. If you do that, you're going to be fine. Otherwise, you're climbing over each other to get to your seats, and I apologize for that. It's a rule that I always say, and for whatever reason, I forgot this time, and sometimes I do, and I apologize for that. So you've all been given juror buttons, and you have notebooks with notepads on them. And here's a couple of things that I want to talk to you about. While you are in the courthouse, please wear your juror buttons. You don't need to wear them outside of the courthouse, but please wear them inside the courthouse. It does a couple of things. First of all, it lets everybody know that you are a juror. So you may see other jurors that are wandering around with other juror buttons as well. What that does is it tells people that you are a juror. So it means that if potentially you run into witnesses, attorneys, somebody who may know something about the case, they will stop talking when you are around. Don't take that personally. They're trying to avoid even an appearance of impropriety. Again, don't take that personally. Secondly, it identifies you as a Division 15 juror. The courthouse can be intimidating. It can be overwhelming. And the architects who designed it designed all the hallways to look almost identical. It's an unusual place. People are sometimes anxious when they get here, even jurors as well. And so sometimes they get off on the wrong floor. And we have had jurors in the past become misplaced. Having that button on explains that you are a Division 15 juror. It will help a staff person help you get to where you need to be. So please wear them in the courthouse, but you do not need to wear them outside the courthouse. Mr. Combs has told you how to get in the courthouse in the morning. When you get out of the court, or when you come back after lunch, you'll come back through the Tejon Street exit, just like you did when you first came here, and how you got in this morning. You'll use that same process. Just come up to the 4th floor. Did you show them the video phones?
No, Jack talked about it.
Okay, so before you go, they'll show you where the video phones are, but they're right outside the elevator. You'll need to call us and we can let you in. So in addition, you've all been given juror pads. They have some information, parking information for you. That's typically the one that is the most important for the jurors. We will also have some parking passes for you towards the end of the day. Don't leave without getting one of those. Make sure that you get one. It will make your life easier. It also has contact information for the county in case it gets lost, but I don't anticipate that's going to happen. But in the event that you need the contact information, it's also there. Your packet also has a question form on it. In Colorado, we do not allow, or we used to not allow jurors to ask questions. There's been a number of reforms over the years, and one of the reforms is we do allow jurors to ask questions of witnesses now. It has to be in a very specific format, however. You do not get to stand up and do your very best Perry Mason imitation. Instead, what will happen is when the witness comes on, suppose the prosecution is calling the witness will take the witness stand, the prosecution will ask some questions, the defense will cross-examine, and then the prosecution will do something called redirect. After that, the lawyers are done. What I then do is I ask, do any of the jurors have any questions for this witness? If so, you raise your hand, you write your question down, you put it on the bar in front of you, I'll have somebody retrieve it. They come up here and you get to listen to that wonderful noise. And the attorneys and I will talk about your question. I have to apply the same rules of evidence and law to your questions as I would to a question asked by an attorney. If the rules of law and evidence don't allow your question to be asked, I can't ask it. I can tell you that over the years, I've asked probably better than 95% of the questions that are submitted. If I don't ask a question, it's not a reflection on the juror, and you should think nothing of it. In addition, you shouldn't guess or speculate as to what the answer to that question may be. In addition, you've been given notebook paper. You can take notes. The notes are purely and entirely for you and you alone. Once this case is done, those notes are immediately destroyed. Nobody reads them. We don't grade them for penmanship, accuracy, anything else like that. So whether you want to take notes or not, it's entirely up to you. I am going to read a couple of instructions that may help you going forward. One of the instructions is you may have to decide what testimony to believe. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while on the stand. Consider the witness's means of knowledge, ability to observe, and strength of memory. Consider also any relationship each witness may have to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence which affects the credibility of the witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. In addition, evidence may be either direct or circumstantial. Circumstantial evidence is the proof of facts or circumstances from which the existence or non-existence of other facts may reasonably be inferred. All other evidence is direct evidence. The law makes no distinction between the effect of direct and circumstantial evidence. Suppose, for instance, that when my children were younger, they had baked some chocolate chip cookies, and I told them that they couldn't have any until I got home. So I get home, I find the lid off of the cookie jar, and I find half of the cookies gone. I could conclude from that evidence alone that it most likely was not my teenage son that got into them because there are still some left. So I think of the next most logical culprits, and I call the twins downstairs. Sam comes down looking like she always does. She has a nice clean face and a nice clean shirt. I ask her if she had any of the cookies. She says no, at which point Kate comes barreling around the corner, running into Sam, and she has some crumbs on her mouth and some chocolate on her shirt. I did not see Kate actually take the lid off of the cookie jar, reach in, and take out a cookie. But I can conclude from what I do see, that's exactly what she did. The law makes no distinction between the effects of direct and circumstantial evidence. When you come back this afternoon, what you can expect is that we will have sort of a short afternoon. And this is on me because for planning, I wasn't sure how long it was going to take to get through the jury process this morning, whether or not we would still be in it this afternoon. So I anticipated that potentially we might have gone into this afternoon. So I flexed that with the attorneys. I said they did not need to present any evidence this afternoon. Evidence will start tomorrow morning at 9 o'clock. But when we come back this afternoon, what will happen is the prosecution will start their opening statement, and I've limited each side to an hour. So the prosecution goes first, then the defense goes. Then we will take a break for the day. I'll send everybody home. I'll have some further instructions for you at that point in time. When you come back this afternoon, feel free to bring in some water, some pop, some coffee, anything like that that you would like to. If you want to drink something in the jury box, that's okay. Generally, I can't allow food in the jury box. If somebody is diabetic or has an issue with respect to that, let me know because there's a way that we can deal with that. So let us know if that's an issue. You can feel free to stand, stretch. Those seats I know are not the most comfortable. I get it. I sit in one that's similar to that a lot. So I understand that. In addition, don't think we have that juror, but in addition, for any of you who are vertically challenged, sometimes you'll find that the seats don't go down low enough. And if that's the case, we have something that you can rest your feet on so you're not feeling like a 5-year-old in a barber chair. And we got one. We got you taken care of. So we will get one of those, and that should help. The other thing is that feel free to bring in a jacket or something like that if you want to. It always feels warm in a courtroom to me, but that's essentially because I'm wearing a blanket all day long. But if you get cold or something like that, just feel free to bring in a jacket. Again, as you know, most of the eating joints are north on Tejon. There are a few south on Tejon. And your day going forward, your court days will look like this. We need you to be in the place you need to be to meet Mr. Combs in the morning, and he'll get you here so you're here at 9 o'clock. We will start at 9 o'clock. We'll have about a 15-minute recess or a little bit longer than that, somewhere between 10 and 10:30 every day. We'll take a break at noon. We'll come back at 1:15, 1:30, something like that. And we will go into the afternoon, and we will have about a 15 or 20-minute break somewhere between 3 and 3:30 in the afternoon. Then we will stop at 5 o'clock. When we stop, you will be free to return home. Again, you can go on about your business, do anything that you would normally do, except talk about this case or do anything with respect to this case. If you have questions or issues, contact Mr. Combs or Mr. Sproul. They will let me know. And I think that covers most everything that we need to cover. So if we can have everyone back in the jury rooms a little bit before 1:30 so that we can start on time, we should be able to do that. Sounds like it's a beautiful day outside. If you want to go for a walk, that's fine. And we'll see you back at 1:30. All rise for the jury, please. Thank you. You may all be seated. The record should reflect the jury has left the courtroom. So we'll be back at 1:30. We'll start evidence tomorrow at 9 o'clock. And I think that's it. Anybody have anything else? Prosecution, defense? Okay, all right, thank you. Court will be in recess. There we go. You're using that Ms. Gratiano, you're using that laptop, right? That's what should be coming up on the screen. Okay. Yep. We good? All right. Let's go ahead and bring the jury in. Becky, are you using this for bench conferences or? Okay. I'm actually checking it again. All rise for the jury, please. Yes,
Remain on throughout the trial, or is it something?
unless I turn them on, and I will let you know if I do
Okay.
that. Thank you. You may all be seated. Court will call 20 CR 1358, People versus Letecia Stauch. Record should reflect the jury has returned to the courtroom. Good afternoon, ladies and gentlemen. When we took our recess, I told you that we would start with opening statements at this point in time, and that's where we will begin. Again, remember that nothing that the attorneys say is evidence. This is this is sort of an overview of what they believe the evidence will show. With that, prosecution. Go ahead.
Oh, I was asking if you could turn on.
You want it now? Go ahead. Okay.
And if you want to dim the lights, I'm fine.
I can't, actually, I thought this was for perimeter lights like it is in my courtroom, but it's not. Their panel is up there. If you want to dim the perimeter lights, it's up to you. Okay, all right.
Well, ladies and gentlemen, here we go. Paramount question you will have to answer as jurors in this case has to do with sanity, specifically the defendant's sanity. At the conclusion of the evidence, the court will give you jury instructions. One specific jury instruction will talk specifically about insanity. It will read that as to the question of sanity, the defendant was insane at the time of the commission of the acts if she was so diseased or defective in mind at the time of the commission of the acts as to be incapable of distinguishing right from wrong with respect to that act, or she suffered from a condition of mind caused by a mental disease or defect that prevented her from forming a culpable mental state. That is an essential element of a crime charge. A culpable mental state is like an intentionally or knowingly. Evidence in this case will show that she could distinguish between right and wrong, and that she was absolutely capable of forming the specific intent required for these charges. Those instructions will go on to give specific guidance on what qualifies as a mental disease or defect. It says care should not be taken to confuse mental disease or defect with moral obliquity, mental depravity, passion growing out of anger, revenge, or hatred, or other motives and kindred evil conditions. Because when an act is induced by any of these causes, the ones that I just listed, the person is accountable to the law, meaning that person can be found guilty for committing crimes charged. You should consider the evidence you will hear in this case in context with that instruction. This case is about two people. First is Gannon Jacob Stauch, an 11-year-old little boy. Came into this world premature, weighing just 1 pound, 6 ounces. He proved to be a fighter, overcame the difficulties associated with being born so small. He's survived by his mother, Landon Hyatt, his father, Al Stauch, and his precocious little sister, Lena. On January 26, 2020, something bad happened inside the Stauch family home. Gannon suffered some burns. You'll learn this from a video recording this defendant made that night, January 26th. You'll hear her as she manipulated Gannon, putting guilt on him for some mistake that a child made. And in that recording, you'll hear Gannon say in his own words, "I'm just worried about my burns."
Two, I just don't know what to do.
Well, devastating. Initially, Scott, I can't lie when the TMZ information.
Gannon, I promise it's the last time I'm gonna ask you. I'm just freaked out, okay? Are you sure you didn't do it on purpose? Okay, we promise. You promise. Pinky promise. Okay, all right, so listen. We're gonna have to sell stuff to fix it, okay? So we figure out what we gotta sell. We can sell the sofa. We can sell whatever, because we gotta get it fixed. So lady, don't be mad at us and kick us out the house. Okay? You got it? You got it?
I'm just worried about my friend.
Okay, shh, listen. So tomorrow,
The other person in this case is that last voice you just heard, who said so tomorrow. This lady sitting right here, the defendant. January 26, 2020, and into January 27, 2020, she was the sole provider for Gannon. Her husband, Al Stauch, Gannon's father, serves in the National Guard. He was in Oklahoma for National Guard training, left that Saturday night, the 25th. Everything that happened to Gannon from that point forward was her decision. She carried out actions to kill Gannon, to put his body in a suitcase and hide it, to hide evidence of what she did to Gannon. Told numerous stories to investigators to manipulate the course of the investigation. And finally, to discard Gannon inside that suitcase off of a Florida bridge like garbage. January 27, 2020, Gannon's home, located at 6627 Mandan Drive, here in Colorado Springs, Colorado, turned into the stuff of nightmares. In fact, the one place a little boy like Gannon should have felt the safest, his bedroom, turned into, like I said, the stuff of nightmares. That bedroom is in fact where he was brutally murdered. The defendant attacked him viciously, mercilessly, deliberately, and intentionally. These are exhibits that you'll see from the doctor down in Florida, Dr. Ignacio, when she performed the autopsy. She'll tell you that Gannon suffered 18 stab wounds to his body, his chest, his back, his head, and most importantly, his arms and his hands. Why is that important? Gannon was fighting for his life, and those were defensive wounds. Next came a crushing blow to his head that was so strong, it fractured his skull like an eggshell. That wasn't enough for this defendant. He retrieved a 9mm handgun, fired it at Gannon 3 times. 2 bullets struck the pillow near him and were caught in the fibers of that pillow. That 3rd bullet entered his jaw, traveled through his head, fracturing his mandible, his vertebrae, hitting his spinal cord, and lodged in the back of his head and was recovered at autopsy. Gannon's life drained from his body, drop by drop. The photo that's on the screen right now is a picture of his bedroom. Same corner where he was in that picture, or where you'll see him in the picture in the bed. Each one of those markers signifies a small blood drop that splattered across his wall. It ran down the corner of his mattress, soaked through the carpet padding, and puddled on the concrete foundation below that carpet. The defendant then took very deliberate action. She decided to hide her crimes from the world, and she took action to hide those crimes from the world. She collected Gannon's bloody and broken body and the blankets and pillow that were near him and shoved them into a suitcase and hid them in the storage unit in that basement. That basement storage unit is right around the corner from Gannon's bedroom. What she didn't know is that she was leaving clues behind in that storage room. That plastic tub that you see in the bottom left portion of that picture has Gannon's blood on it. There was an Amazon box in that storage room that has Gannon's blood on it. The concrete floor in that storage room had Gannon's blood on it. The defendant next decided to clean Gannon's room. Deliberately, intentionally, knowing what she was doing. She scrubbed the walls, cleaning them off. She scrubbed the carpet with scrub brushes that were later found in the dishwasher. Those scrub brushes have carpet fibers in them. They have blood on them. They have Gannon's DNA on them. This is Gannon's bedroom when members of the El Paso County Sheriff's Office first came to the house on January 27th in the evening hours. This is what it looked like. No obvious signs of a struggle. No obvious signs of blood as they walked through the house and through Gannon's bedroom. There were no obvious signs of a struggle or a murder because the defendant had cleaned them up. And also realized she had Gannon's blood on her person. Clothes that she was wearing, likely containing Gannon's blood, based off of how much blood had hit the walls, were never found. Her clothing was never found. These shoes, the defendant's shoes, were found on the washing machine, drying. That reddish rust color that you can see on the soles, Gannon's blood and DNA were found on those shoes. You can see just how much blood she was walking through. She was cleaning up that mess. Took more deliberate action. She collected and discarded other important clues. I mentioned she stabbed Gannon 18 times. The instrument that she used to stab Gannon has never been found. That 9mm handgun that she used to fire 3 rounds at Gannon, shell casing ejected out of that firearm each time she pulled the trigger. No shell casing was ever found in Gannon's room. She then took more deliberate action when she hid Gannon in a suitcase, first in her car, and then up north, the El Paso County, Douglas County line. GPS location data was used to track her locations or her movements. And it led to another grisly discovery up just in this area here. A board was found under a tree. That board had Gannon's blood on it. This is miles away from the Stauch family home, which is in the southeast part of the city, close to the airport. You'll learn through testimony that this board came from the Stauch family garage. Then took more deliberate and thoughtful action. She loaded the suitcase containing Gannon into the back of a rented van and drove to Florida. And that's the course of her travels from here to Florida. She rented a hotel room in Pensacola, Florida on February 4th, 2020. She drove a short distance from that hotel room, which is sort of by those blue angular marks on the map, up to where that red square is on the map. Drove a short distance from that hotel room, across a dark bridge that drives over a river that flows into the Gulf of Mexico. There she acted with determined purpose. Stopped that van. She hauled the suitcase out of the back of that van, drug it to the side of the road, hoisted it up over the railing, pushed it over the side, hoping that Gannon would never be found. 48 days later, 1,300 miles away from where Gannon was murdered, the search for answers and Gannon's remains finally ended on March 17, 2020, when the suitcase that came from that basement storage room, Gannon's remains, blankets, and the pillow were found by an unlucky bridge worker checking that bridge for safety. And imagine the shock that he felt when he realized what was inside that suitcase. Inside that suitcase, obviously Gannon's decomposing remains. Also, these 2 blankets and that pillow. Remember the pictures that I showed just a moment ago of Gannon in bed? These pictures were taken by this defendant on the morning of January 27, 2020. Sent them by text message to Gannon's father, Al, who was in Oklahoma for training. Take note of those blankets. Take note of the blankets that were recovered from that suitcase. The very same blankets and pillow that were in those pictures on January 27, 2020 were found 1,300 miles away with Gannon underneath that bridge. The defendant then purposely, intentionally came up with numerous different stories about what had happened. Gannon was missing, went to a friend's house and never returned. Gannon was kidnapped and she was raped by a guy named Eduardo. Gannon was kidnapped and she was raped, but this time by a guy named Quincy Brown. She went to look for a bike up near that Douglas County, El Paso County line. Gannon test rode that bike, crashed, and suffered a horrible head injury. And a guy named Quincy Brown takes Gannon, and now the defendant doesn't know where Gannon is. Cartels were somehow involved with Gannon's disappearance. And most cruelly, that Landon Hyatt, Gannon's mother, was involved with Gannon's disappearance. All of her actions were purposely designed by her to distance herself from what she did. Throw off investigators, buy her time, escape accountability for what she did to Gannon on January 27, 2020. At the conclusion of the evidence that we'll be presenting in this case, you'll be asked to determine whether the defendant is guilty or not guilty of the charges that we've leveled against her. You'll also be asked to determine whether she was sane or insane at the time that she killed Gannon. All of her decisions, all of her deliberate actions betray her claims of insanity. She knew that what she had done to Gannon was wrong. Why hide it? You'll hear her own voice through recorded phone calls and interviews. The evidence itself will prove her sanity. As jurors, part of your job will be to determine how much credibility, if any, you give to the witnesses. That same rule applies to expert witnesses. You'll get to hear from doctors. You'll get to hear from GPS expert witnesses. Lawyers get tongue-tied sometimes. And when they take the stand and take an oath, you get to judge whether what they are saying makes sense. Is it credible or not? And if it's not credible, you get to discard it. If it's credible, you can use it in your deliberations. But you all get to decide whether that credibility extends to that witness or not. The same will hold true for our expert witnesses and the defense expert witnesses. Get to hear from a doctor that will testify that the defendant was insane at the time of the murder of Gannon Stauch on January 27, 2020. With all expert witnesses, you should gauge what they're saying, measure it against the other evidence that you're hearing. Does it make sense or not? Like all expert witnesses, if it doesn't make sense, you can discard it. You'll also hear from others who knew her best. People that have the best opportunity to see how she was acting. Did she understand the difference between right and wrong? Could she form intent? People like Al Stauch, the man who was married to her. People like her brother, Dakota Lowry, who flew out here after Gannon went missing. And most importantly, her very own daughter, Harley Hunt. See, Harley Hunt was at the best position to know the defendant's state of mind, especially as it relates to when this crime occurred. He was the only other older person in the house. When Al left to Oklahoma, Harley Hunt was working. She's young, 17 years old at the time, thinking about going into the Air Force. But she becomes the defendant's closest confidant after the defendant killed Gannon Stauch. In fact, she also rode with the defendant on that van ride from Colorado Springs to Florida. She'll be able to tell you in her own words whether the defendant understood the difference between right and wrong, whether she could act intentionally or deliberately or not. And she'll tell you that she could on both counts. Remember, this case is about two people. Gannon had no choice what happened to him that day on January 27th. The other, this defendant, she held every single decision in her hands. She took deliberate, thoughtful actions that ended a precious life and tore a family apart. Your job as jurors will be to listen intently to all of the evidence. Because even the most mundane evidence, it might seem inconsequential when you're listening, is being given to you purposely so that you can make the determinations you need to make as jurors. Did she understand the difference between right and wrong? Was she able to form a culpable mental state? Every single piece of evidence that comes from this chair will be used by you to make that determination. The next time I get to talk with you directly the way I'm doing right now, I don't mean we've concluded evidence and we're giving closing arguments. At that time, both sides will get to ask you to make determinations based on what you all have heard. We're going to ask you to hold us to our burden of proof. The criminal justice system doesn't work if you don't hold us to our burden of proof. Our burden of proof is proof beyond a reasonable doubt. The things we have to prove are the elements of the crimes charged. We also have to disprove that the defendant is insane, meaning essentially You have to prove that she was sane. The evidence will do that for you. We will ask you to give justice to Gain and Stauch. We will ask you to find this defendant guilty for what she did to him more than 3 years ago. We'll ask you to find her guilty of murder in the first degree. Murder in the first degree of a child under 12 years of age. Tampering with a deceased human body for taking Gannon's body from that scene and transporting it across the country. And tampering with physical evidence. We'll ask you to convict her on each and every one of those charges. And the evidence will guide you towards those convictions. On January 27, 2020, 6:55 p.m., the defendant herself called 911. She called 911 to report that Gannon was missing and not come home. Call taker you'll hear ask the defendant, who was the last person to see Gannon?
Who was the last person to see him? I guess me?
The evidence will show that she was the last person to see Gannon alive. The evidence will show that she was sane on January 27, 2020, when she ended Gannon's life. The evidence will show that she acted intentionally and deliberately when she took Gannon's life. And then we will ask you to convict her. Thank you.
All right, thank you. Defense? Mr. Cook?
Good afternoon, members of the jury. I talked to some of you during jury selection over the last couple of weeks. To some of you, I want to reintroduce myself. My name is Will Cook. I, along with Mr. Cellini, represent Letecia Stauch. Now, this is a very tough case. We looked at the jury questionnaires, prosecution. There was a lot of strong feelings. Questionnaires. Have you formed an opinion about Ms. Stauch? Got a lot of she's guilty. Got a few she's evil. People forming opinions about this case before they ever hear one shred of evidence. As a defense attorney in this case is very worrisome when people have come in and they have preconceived notions of what's going on. With respect to the question on the paperwork that you got about insanity, what do you think about insanity? Is it valid? Something that's legitimate. A lot of people said insanity is just a way to get out of taking responsibility. It's an excuse. It doesn't exist. It's fake. Got a lot of that. So I, as the defense attorney, have two big problems in the case. I represent Ms. Stauch, who, according to a lot of jury questionnaires, is evil and guilty. And us raising insanity is a bunch of BS. A lot to deal with. Been looking at this case for going on 3 years now. All the photos, I've seen all the reports. Mr. Cellini has. It's a lot. What you saw on the board this afternoon, that's the PG stuff, the rated G information, photos you're going to see. For a general audience, go forward in this case, you're going to see the autopsy photos. going to see the photos of when Gannon was brought out of the suitcase. And they're horrible. Horrible. It was an awful, awful thing that was done to Gannon. And I see Mr. Allen get up here and he's emotional, almost into tears talking about it. And I get it. I get it. What happened to that little 11-year-old boy is beyond description. The facts of this case, awful. You know, it's so bad. This is a lost cause. Ladies and gentlemen, I can't quit. I can't leave this courtroom. Got to do my job in this case. Mr. Tellini does. I can't just, after that opening statement, all the information that I've seen, the photos, the smiling picture of Gannon, hearing about him being shot and stabbed multiple times, hundreds of witnesses, and 800 pieces of evidence that are going to come in. I can't check out now and just sit down and write this out. I can't do it because it wouldn't be fair. Wouldn't be fair to the court system, the process, and it wouldn't be fair to Ms. Stauch. And I know people will say, well, who gives a shit about what's fair for Ms. Stauch? The court systems do. The law does. The Constitution, the Bill of Rights. The war fought over these things that we're dealing with today. Old school laws, the presumption of innocence, right to remain silent, stuff that comes all the way back from old Boston and Paul Revere riding through the streets on his horse going, the British are coming, the British are coming. Old stuff, and it matters. And once we decide something in the media, before you have heard one shred of evidence, prejudge this case before anything has taken place, then all of that is lost. And we are truly a country that is no longer ruled by law, but by the media. I get it. We've lost. Mr. Tellini, we lost. Stauch, we lost. We have lost in the court of public opinion and the media. He's guilty. I get that. This is a court of law. As Judge Werner said, Come through those double doors there. This is a special place. This isn't the media. This isn't Facebook. Wash all of that away. Don't try to get up and walk out of the courtroom before you started. Do your jobs. Listen to the evidence. When the evidence is complete, go back into the jury room and weigh the evidence. All I'm asking of you, just give us a fair shake. I can see it in your eyes, ladies and gentlemen. A lot of you, as far as you're concerned, I could burn in hell for representing Miss Stauch. A lot of you won't even make eye contact with me. I might as well just be the devil himself up here running his mouth. But I'm not. No different than those three at that table right there. Paid advocates. Werner here in voir dire says they are paid advocates. Leanie and I were paid advocates. They have their side of the story. And I just want to be heard. Want our side to be heard. And if at the end, guilty, but you weighed the evidence, you listened, you didn't prejudge the case, your biases, your sympathies, your prejudices that you had at the beginning of this trial, if you didn't let those come in, were fair and impartial, but it's still guilty, I'll take that. I'll take that in a case like this. A lot of evidence. Very, very difficult case. So don't quit on me. Now, Mr. Allen is right. He's a good attorney. He's well-spoken. He elected DA. This is going to come down to insanity. Lady here and was killed back in January 20. How do you figure that out? How do you look into the mind of a sick person and divine what they are thinking? Well, evidence, people's statements, observations, recorded statements, phone call, heard Ms. Stauch talking on. That's good stuff. What else can you look at? Motive. Somebody's motive. Remember that word? Up every day during jury selection for the past 2 weeks by the prosecution. Motive. You were told, and rightly so, by the prosecution that there is no requirement for the prosecution to prove motive. They're right. Does that mean that motive doesn't matter? No, it doesn't. Not mean that. Even though jury instruction talking about insanity, the prosecution just put up on the board, talked about motive or lack of motive could be a sign that there is insanity or not insanity. And it's in the jury instruction there. So it does matter. It's not required, but it matters. And it matters because it's evidence. You don't have a motive, that goes to show a lack of evidence. Say there's a couple people involved in a shooting and a murder out in the community. Paper reports it as a random, senseless act of violence. One person shot to death. Police investigate. They have 3 people that are suspects that were there at the scene at the time of the shooting. One problem for the investigators. Don't really have any other evidence. A week later, doing some good police work, they uncovered that one of the 3 people was a drug dealer who was ripped off the week before the shooting by the dead man. A lot of money and drugs were stolen. All of a sudden, with that information, this random, senseless act of violence becomes a murder with a motive. It does matter. Could you?
You need to put it up. It's not hooked up yet. You can turn off the perimeter lights if you want. I'm not getting a feed come through. You are hooked up to the defense. Still not coming through. Oh, there you go.
Enlarge that or
That's what you're looking for, right?
that's the photo. Ladies and gentlemen, if you will turn your attention to the 2 boards, screens. This fancy pointer that you were alluding to, Judge. Extendable. All right, we've got a photo here. We've got some familiar looking faces. Gannon, Letecia Stauch. Stepmom, stepson. Gannon's little sister in the back. You look at that. Looks like everybody's doing pretty good. Happy, sunny day. Maybe Miss Stauch is doing a selfie holding the camera out. Whatever. When would have this photo been taken? The day before Gannon died. The day before he was killed. It wasn't a photo of evil, anger. A photo of someone, by all accounts, who was a loving stepmother, care of Gannon. Gannon's father was on a deployment. Stauch worked as a teacher herself in the Whitefield School District, an elementary school teacher. Got a person that was, living It seemed like the American dream in a nice suburban house in Morrison Ranch, the suburbs of Colorado Springs, Colorado. But behind those photos and miles, Stauch. Oh,
Yeah, I did.
okay. Stauch was hiding Stauch was dealing trauma and abuse that had been going on since she was a toddler. A troubled childhood. Mother wasn't really much of a mother. She had a line of stepdads or boyfriends or whatever. Her mother, come in and out, come in and out, in and out, in and out of her life. From the time she was 3 or 4 years old, Miss Stauch, until she finally moved out. And she suffered. She suffered horrifically from these stepfathers, these boyfriends of her mother. Watched her mother get beat by the boyfriends, physically abused, until eventually the physical abuse these men reserved for her mother eventually trained on the Stauch here. Little girl. First, it was just physical beatings, whoopings, emotional abuse, verbal abuse, and then it became sexual, where she was molested regularly. Five or six until she was a teenager. Constant. She used to have to sleep in the car out in the driveway to get away, not have to molested and sexually assaulted by these men. Sleep in the car in the driveway of her house. And because her mom wasn't around a lot, it's kind of an absentee mom. A lot of these stepfathers, if you could call them that, cared for Miss Stauch exclusively. Mom was out somewhere doing something, gone for several weeks at a time. And Miss Stauch, as a young child and a young woman and a teenager, was left in the care of these men. How do you deal with this? You're 6, you're 7 years old. What do you do? Physical abuse, sexual abuse, emotional abuse. How does a kid handle that? Well, a lot of people that have had bad childhoods go on and they're fine. There's some that don't. Is a survival mechanism. Some of these children's personalities fragment. And why do they do this? This fragmentation of the personalities when there's abuse at a young age. Because in the case of Ms. Stauch, her abuser was also the person that provided her means for survival. A 4, 5, 6-year-old kid does not go out and get a job and work and acquire their own food, pay the electric bill, pay the rent. So while they're being abused, they also, as a matter of survival, have to both hate and love, to fear and placate their abuser / caretaker. How does a person do that? Well, I think in a lot of situations, no one person can do that. That's where the fragmentation personality comes in. All the good and all the bad, all the evil and the hate can't reside in one place. And I know some of you, based on your jury questionnaires, think I'm telling some fanciful tale about this. I get it. I read the questionnaires. But as such, you have sworn an oath multiple times to follow the law and the evidence. Don't like insanity or dissociative identity disorder. That's okay. Joke or an excuse or not valid. That's okay. It's okay if you think that outside those doors. In here, you got to believe it's a legitimate mental health defense, that in fact it exists and that it is scientifically backed. You're going to hear doctors, sworn experts on both sides. So yeah, it's in the DSM-4 or 5, which is the book of psychological ailments and issues psychologists and psychiatrists use to diagnose things. It's listed, accepted in the scientific community issue, a real issue, dissociative identity of multiple personalities. Now, whether you believe or their experts believe what our expert believes about whether it was present in this Stauch's case, different issue. But you must, to be fair, impartial, and unbiased, you must believe that it is a possible defense. It is a valid defense. It is a valid defect or disease of the mind that triggers the insanity provisions under the Colorado laws. Laws that trigger when we bring in some testimony or some evidence that there is insanity causes the rules, the laws to pivot. So that the prosecution has the burden of proving beyond a reasonable doubt let's say In this case, circle back around. Why all of that just matters. Going back to motive. Evidence, exhibits, photos, videos. We're going to be in here for 8 weeks. School's going to be out. Making plans for our Labor Day barbecues, not Labor Day, barbecues by the time we get done. But you know what you're probably not going to hear? During all that time with all those exhibits, all that evidence. All those witnesses. You're not going to hear about a motive. You're not going to be given a motive about why Ms. Stauch, January 2020. Reason is there is no motive. There is no reason. Doesn't make sense. It's insane. Smiling photo. Next day, Shannon's gone. No reason for it. Prosecution may say, oh, well, makes it that more tragic that it was such a pointless death of Gannon. I don't know. I'm not going to speculate on that. But there was some major psychotic crack that went on during this time. Go from teacher, loving stepmother to 2 children, loving mother to her own child, Harley, a person that Shannon's father entrusted his own 2 kids, watched and loved and by this woman here. Being a killer of a 11-year-old boy. How do you get there? Big jump. There is no explanation for it. I don't have one. She broke on that day, ladies and gentlemen. She broke. Broke from all that was right. Made sense. And the axe, putting Shannon's body in a suitcase and traveling 1,300 miles, whole of Florida, and throwing the suitcase, Shannon's body in it, side of an overpass. Different stories she told. She was raped by somebody. Person who raped her, kidnapped Gannon. Hear all the stories. The prosecution's going to play it for you. These are all signs and evidence of a mind a soul that is broken, most fundamental and profound way. So broken, doesn't even know what it was doing. What was going through that person's head? The killer Gannon's head. Stauch's head. All the stab wounds, the shootings, the bruisings, the beatings, the burns. What was going through that person's head? I don't know. I don't know. I couldn't tell you. For the person that she was killing that day, attacking, I wasn't Gannon. Wasn't Gannon to her. Wake up that day and go, I'm going to kill him. No. She was killing the demons, her life, from the dark depths of her childhood and her life. You're going to hear different doctors. We have a Dr. Dorothy Lewis. She's from Yale. She's been at it a long time. An MD, got a lot of experience with this. Her legal medical opinion is that on the date of this offense, Ms. Stauch was legally insane. Now, the prosecution is going to have some witnesses from our state mental hospital in Pueblo that I imagine are going to say, no, she was perfect. She knew what she was doing. It's normal behavior for a person to do that. Yeah, she had some mental issues and everything like that, but everybody does, but they don't go and kill an 11-year-old boy. And that is true. A lot of people do have mental health issues. It was talked about in voir dire. People have very severe mental health issues. They don't go out and kill people. And they don't go out and kill 11-year-old boys or their stepsons. They had had a nice hike just the day before, as evidenced by that photo. Don't stab the stepson dozens of times. Discharged 3 bullets, a 9mm handgun at the boy, hitting him once, killing him once. Beat him, burn him, and do all these other things you're going to hear about. Wrong, and it's horrible. She not sane. And she will be held accountable. Not guilty by reason and insanity. We'll get a jury instruction. It's about a paragraph long. It indicates in that case, and I think Judge Warner alluded to it, to one panel of potential jurists in the last couple of weeks. She's found guilty, then it's guilty. She's subject to regular sentencing by the court. But if I'm not guilty by reason of insanity, doesn't mean she walks out of here. She's committed to the state hospital Colorado Department of Human Services, and they take over from there, State Mental Hospital. That's not what we're dealing with here now. So I know there is a natural urge, human urge, a real urge. You hear about that little boy with that big bright smile that you saw on the screen. Hear about what happened to him. Want to make somebody pay. Want to make somebody pay dearly. Not right. Happened to that young. Awful. But not providing Stauch constitutional protections for presumption of innocence, the right to remain silent, placing the burden of proof squarely on the shoulders of the prosecutor, letting bias or sympathy come in and cloud your judgment. Not going to bring Gannon back. Prejudging the case by what you've heard in the media. To do no good. No, we have a tragedy here. And we know it's terrible. But just listen to the evidence, as I started out with. Don't check out. It's going to be easy. Went into week 6, hearing all these witnesses and looking at evidence. You're going to want to check out. You're going to want to form your decision soon in this case. But you can't do that. For the next 6 to 8 weeks while we're in this trial, can't form an opinion. Werner was telling you that. You're in an evidence gathering phase now. You're gathering the facts. Like Judge Werner's Miss Denver omelets, this is the ingredient gathering stage. Okay? It's in the cooking stage. When you go back to the jury room after all the evidence is in, you start putting the ingredients together. For omelet, or just a ham and cheese omelet. Whether you've got a guilty, not guilty, or not guilty by reason of insanity, based on the evidence, the ingredients. When you're in the jury room, that's when you start putting it together. Just writing down, taking notes, taking it all in. That's why the judge mentioned several times to you today, I don't want y'all talking about the case amongst yourselves. Kind of a special, hidden, quiet place, this courtroom, especially you jurors. I don't want y'all talking about the case because that leads to deliberating and judgment. It's in the judgment phase. So, thank you for your time. Thank you, everybody, for coming back. We'll be spending a lot of time together over the next couple months, so keep an open mind. Put a lot of the bad stuff that out of your mind for now. What the prosecution has to say, hear what the defense has to say. At the end of this, as Mr. Allen said, when he's concluded his opening statement, he said, I'm going to come back in a couple months and ask you to find her guilty. I or Mr. Tellini in 2 months are going to ask you to find her not guilty by reason of insanity. Now the trial starts. Had opening statements, you've had all that now. He said, and I said, it's not evidence. Checked it up on the board and the videos and the audios that he played. That's not evidence. Or what the judge said. If you had to deliver a verdict right now, it's not guilty. Woman right here is not guilty. He's presumed innocent. Not telling you to like it. I'm just telling you that's the way it is. I'm going to stop now because I'm running out of steam. But I really, really, really do appreciate your time. I know the judge, Hayes due, said earlier, you're the ones that are making the sacrifice. You're the ones that, are losing money because you're not able to go to work. That, your workspaces, your offices are idle because you're going to be here for 2 months. What we do, this is where we work, all of us, the attorneys, we pay. They're the ones that make the sacrifice in this case. And I do appreciate it. And on behalf of my attorney, Mr. Tellini, I know he appreciates it. Thank you.
Todd, can you get the last perimeter light, please? I'm not sure which one it is. Thank you. All right, ladies and gentlemen, I want to give you a little bit of roadmap as to what you can expect and where we go from here. As I said this morning, opening statements are not evidence. Their purpose is only to help you understand what the evidence will be. Keep in mind that in this case, as in every case, attorneys are paid advocates. Their job is to persuade you that evidence proves or does not prove a particular point. And as I said earlier, nothing an attorney says is evidence, and they do not take an oath to tell you the truth. Next, the prosecution will offer evidence. Evidence consists of the sworn testimony of the witnesses, the exhibits received in evidence, and stipulated, admitted, or judicially noticed facts. After the prosecution's evidence, the defendant may present evidence in her own behalf, but she is not required to do so. I want to remind you that the defendant is presumed to be innocent. The prosecution must prove the guilt of the defendant beyond a reasonable doubt. The defendant does not have to prove her innocence or call any witnesses or introduce any evidence. At the conclusion of the evidence, I will tell you the rules of law which you are to use in reaching your verdict. I will read those rules of law to you, and you will be allowed to take them with you to the jury room during your deliberations. After you have heard all of the evidence and the instructions, the prosecution and the defense may make their closing arguments. Like opening statements, closing arguments are not evidence. The prosecuting attorney will have the opportunity to reply to the closing argument made by the defense. You will then go to the jury room to deliberate on a verdict. Your purpose as jurors is to decide what the facts are, and your decision must be based solely upon the evidence. It is my job to decide what rules of law apply to the case. You must follow all of the rules as I explain them to you. You may not follow some and ignore others. Even if you disagree with or do not understand the reasons for some of the rules, you must follow them. You will then apply these rules to the facts which you have determined from the evidence. In this way, you will determine whether the prosecution has proven the guilt of the defendant beyond a reasonable doubt. At times during the trial, attorneys may make objections. That's the part in the TV show or movie where one lawyer asks a question and the other one stands up and objects. On TV, the lawyers start to argue with each other, and then sometimes they go up to the bench and they argue with the judge. I know you're going to be surprised, but that doesn't happen in real life. The lawyers in this room have years of experience. They know that the procedure in this case is governed by a written set of rules that apply to all criminal cases called the Colorado Rules of Criminal Procedure. They also know that the evidentiary matters are governed by a written set of rules called the Colorado Rules of Evidence, which apply to all case proceedings, to all cases proceeding to trial. Watch the lawyers, and you will observe that what really happens is that an objection is made. I will ask for an explanation, something like grounds, for the objection, and the response from the attorney will be something like hearsay or foundation or relevance or 404. And most of the time, watch the attorneys closely, most of the time the attorneys will state an objection in 5 words or less. There's not a whole lot of arguing that's going on during that time period. And regardless, the argument is never directed to opposing counsel, because I'm the one making the ruling and not opposing counsel. So in reality, the lawyers rarely come up to the bench to argue a point, because all they need to do is reference the rule, case, or principle they are relying upon for their objection. In any event, the objection simply means that the lawyer is requesting that I make a decision on a particular rule of law. It is the duty of a lawyer to object to evidence which they believe may not be properly offered. Do not draw any conclusions from the objections or from my rulings on the objections. If I sustain an objection to a question, the witness may not answer it. As jurors, you must draw no inferences from the question or speculate as to what the witness would have said if permitted to answer. At other times, I may instruct you not to consider a particular statement that was made. You must not consider any evidence to which an objection has been sustained or which I have instructed you to disregard. Such evidence is to be treated as if you had never seen or heard it. We talked about the notebooks that you have and the juror questions and the process for doing that. They know where to meet, Mr. Combs? They know where to meet in the morning? All right. Give us just a few minutes and we will get you the parking passes. They're on a lanyard, so keep them because that's what you'll need to get in and out of the juror parking lot. The issue about the truck. Haven't solved it yet. And there's a juror that cannot get into the parking garage because of size of vehicle. Who is that? Just raise your hand. Don't leave yet. We'll talk to you. We'll talk to you. I mean, you can leave the courtroom, but don't leave the courthouse just yet. And for the rest of you, it's going to take just a couple of minutes, unless, Todd, you want to run down there on my bookshelf. Do you know where that is? Okay. And so, Todd, oh, no, I mean, wait, Todd, come back. It's all good. There. So he's going to get you the lanyards with parking passes on them. Use them to come in, and we will talk with juror number 14 about what to do with your situation. We have a solution. Rachel, are you still here somewhere? Stick around. We need to talk. I think we can use the same solution that we did for the other juror that was coming back at 11. That work? Okay. All right. We have a solution, so just hold on and we will get to you. With that, if I can have everyone, you'll know where to meet Mr. Combs in the morning and how to get into the building. We should be able to start right on time tomorrow at 9 o'clock. What you can expect is that we will start with witnesses. We will take a break for 15 or 20 minutes, somewhere between 10 and 10:30. Then we will proceed on to lunch at noonish, come back 1:15, 1:30, have a break, 15, 20 minutes, somewhere between 3 and 3:30 in the afternoon, then recess at 5 o'clock. That's how your day will look every day from here on out. The other thing that you should expect, so that it doesn't catch you off guard, is that every day that we start trial after today, well, I did it this morning actually, but every day that we start trial from here on out, I will ask you a question. And that is, it will be the same question every day. You're going to get sick of hearing it, but it's the same question that I'm going to be asking. Has anything occurred since we were last together that causes any of you to believe that you could not continue to serve as a fair and impartial juror in this case? If so, please raise your hand. So that's why those admonitions that I said about avoiding press, avoiding opinions, avoiding research, all of those things, they all come into play. It's important. This is an important process. So with that, you're discharged. We'll see you in the morning. All rise for the jury, please. Right. The only one that I knew of was Juror 3. Before you step out real quick, does anybody aside from Juror 3 need a letter? Okay. All right, we got it. Thank you. So Juror 16 and Juror 3. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. Mr. Allen, I want to clear up one thing on the record. Because I think it's an issue in, where is this? Where's it listed at though? Charges. Huh, okay. I just want to make sure that the count that you are dismissing is count 3, child abuse resulting in death.
Correct. So count 1 is murder in the first degree. 2 is child under 12. 3 is the child abuse resulting in.
Okay.
That's the one that requires an accumulation of injuries, all that kind of thing, not providing. That was charged before Gaynon's body was ever recovered. When Gaynon's body was recovered, we added 1, which is now murder in the first degree.
Okay, so this would have been, I'm sorry, go ahead.
It's count 3 of the amended information.
Okay, and that's what I wanted to check on, because the original complaint information that was filed on March 11 only has 4 counts, and count 3 is tampering with a deceased human body, and in that one, count 2 is the child abuse resulting in death. So it looks like what happened, they didn't realize the amendment, and when they put it in, that's what the conflict is.
The amendment was filed probably March 18th, roughly.
I have March 20. Yep. Okay. So what you are proposing to dismiss is the one knowingly or recklessly caused an injury or unreasonably placed in a situation that posed a threat of injury to life, health, or safety by engaging in a continuing pattern of conduct that resulted in cruel punishment, mistreatment, and accumulation of injuries. That's the one you're wanting to dismiss.
So count 3 in the amended information.
So it's the amended information. That's where the hang up is. Okay, I think we've got that resolved. Okay, so have your witnesses here 9 a.m. tomorrow morning. We should be able to start right on time at that point. And Rachel, I want to talk to you when we're done. Is there anything else that we need to address from the prosecution?
No.
Defense?
No, sir.
Okay. All right. Rachel, can you come back in the back hallway for a minute, please? All right, court will be in recess. Thank you.